Hi, everyone. It's great to see so many people here. And hi, Betty, I just saw you sign in. Ryan and I are, well, I'll start with, I'll let Ryan introduce himself, but I am, as Kelly said, I'm a staff attorney at Community Legal Services. I work primarily on collections cases and other problems that people face related to debts. And I'm very excited to talk about those issues with you today. Ryan, you want to do just a quick?
Yeah, really quick. Ryan Cummins. I'm an attorney with MidPenn Legal Services out of our State College or Center County office. And I'm also excited to talk about dealing with debt with everyone.
Oh, all right. Now the slides. Now the slides are not advancing. Give me one sec. Okay. So Ryan and I wanted to talk about this topic because we know that obviously debt's a really widespread problem, but it's the kind of thing that you hear about a lot from your clients, whether you're working with them on a debt issue or some other kind of issue. At Community Legal Services, I often get calls or people stop by my office back when people did that because they're working on another issue and they just, their client just has a phone ringing off the hook from a collector and they just want to be able to give them some basic advice. So our hope with today is to kind of run through some of the most common problems that clients deal with when they're dealing with debts and give you the tools you need to give them some basic advice to point them in the right direction, maybe give them some self-help materials or some know your rights information. So we're going to start with hopefully the first 25 minutes or so. We'll just run through some of the most common problems that people face when related to debts. And then for the second half, we'll focus on defending consumers in collection actions. And it won't be, it'll still be at a pretty, not a 30,000 foot level, but it'll be a pretty general overview of collection actions. And if anybody is interested in a more detailed version of that at the end, I'll point you to some resources to a much more in-depth training on collection actions. And I know that there's probably a lot of people on the call who know a lot about these issues. So if at any point you want to jump in and add something, please do so. Feel free to put it in the chat and Ryan and I can stop and open it up to you. Okay, so what we're going to run through here is the most common things that people, that I get calls about. Being harassed by collectors, drowning in debt generally, whether or not they're being harassed, getting calls or letters about a debt they just don't recognize. What is this debt? That's a common thing. Disputing credit or debit transactions, dealing with frozen bank accounts, dealing with high-cost loans or illegal payday loans, student loans, that could be a week of trainings in itself, and then business disputes and scams before we get to collection actions. So I think the most important thing to know, to tell consumers to tell your clients who are dealing with collection problems is that their rights as consumers have nothing to do with how much they owe and whether they owe the debts. Their rights exist no matter what the status of the debt is. They have a right to privacy, to be free from harassment, to decide how they want to be communicated with, and to accurate information. So some of the laws that provide those protections are listed here: the Fair Debt Collections Practices Act, which covers debt collectors, including debt buyers, and also attorneys who are debt collectors. Pennsylvania's kind of counterpart to the Fair Debt Collection Practices Act, the FCEUA, provides a lot of the same protections as the federal law, but it also includes creditors, so it can be a really valuable tool. It's not an exact mirror. So for instance, there's a couple provisions that I'll talk about later that don't exist for creditors, but most of the rules about how they can communicate, things like that, do apply to creditors. So I think the most common, the first advice that people should get if they are dealing with this is that you have the right to control how collectors contact you. They are not allowed to contact you when they know it should be inconvenient. Now, there's some default presumptions for that. So, not really early in the morning, not late at night, not ringing off the hook, not calling you at work when you're going to get fired if you get called at work. But the simplest way to let a collector know that it's inconvenient for you is to tell them. So in the materials that are uploaded to the conference website, we have a sample how to contact me letter that says, hey, you contacted me about a debt. I only want to be contacted between 3 and 5 p.m. on weekdays by phone, and you can just fill in your method of communication. For a lot of my clients, I suggest writing only. especially now during the pandemic when, a phone ringing off the hook can be just maddening and a huge source of anxiety for people of all ages, especially seniors who are, at home even more than usual. In certain circumstances, a cease contact letter might be more appropriate, saying, hey, either I don't owe this debt, or maybe I do owe this debt, but I can't afford to pay it. Please cease all contact with me. Now, of course, the collector in most cases can still file a lawsuit at some point, but they can no longer just send collection letters and call. And no matter what, people should know that if anyone is making any threats, but arrest is not an uncommon threat, or using profanity or anything like that, the Fair Debt Collection Practices Act and the state law protect against that. One really nice shortcut to be able to tell people is to say, look at the bottom of your notice, turn it over, look on the back. Does it say anything about it being time barred? If so, you can just tell them to throw it out and never think about it again. It's a surprising number of time barred debts are still in active debt collection. So if you're going through a stack of papers with someone, you're likely to find at least a couple like that, and it can be really a huge relief to tell someone that.
Laura, before you move on, just really quick, can you help people just to make the quickest distinction between a collector and a creditor?
Yes, thank you. So a creditor is like a typical one is your credit card company. So my American Express, my Visa, my MasterCard, whereas a debt collector could be a third party that the creditor hires to collect on a debt, or it could be a debt buyer, meaning a separate entity that the creditor has given up on collecting the debt, so they sell it to this third party which only exists to collect a debt. And some debt buyers also work as debt collectors for creditors. So sometimes it's not easy to distinguish, but for purposes of how they have to treat you under these laws, debt buyers are considered debt collectors. Thanks, Ryan. When someone calls and just says, I'm drowning in debt. Sometimes they call and say, I'm drowning in debt, I need to file bankruptcy. Or sometimes they call and just say, my phone keeps ringing off the hook. I'll never be able to pay my bills. I don't know what to do. For these people, I think the most important conversation to start with is to talk about, the hierarchy. It's the kind of decisions that our clients know how to make much better than we do in general. But when you're afraid and you're being intimidated by collectors, sometimes that normal rational thinking can go out the window and you're acting out of fear. So I always talk with people about, pay for your essentials first. What keeps you alive, the roof over your head, your food, your gas, your water. After that, pay your secured creditors, like your mortgage. Then and only then, if you have money left, pay your unsecured creditors. And by unsecured, that's typically most of the consumer debts that we're talking about. So, there's no judgment yet, there's no mortgage. It's just your typical credit card bill. That's an unsecured credit card. Ryan and I think both experience that a lot of this work is counseling people about, talking about their debts and working through the shame and embarrassment of their debts. Even though we know how widespread debt is, and it's, practically part of the American way to be in debt, people are really embarrassed about it. They want to do just about anything to avoid talking about it. And then once you've gotten through those things, you assess vulnerability to collection on a judgment. If someone is what we think of as collections proof, then maybe they just send cease contact letters to all their creditors. We have a sample in the materials. Sometimes we give out 10 copies of that to someone and say, you are collection proof, send this to anyone who contacts you and don't give it another thought. So an example of someone who is collection proof would be someone who is a renter. Let's say they're on social supplemental security income as their only source of income. They don't own a car. That person, their income is exempt from attachment in a bank account, so the debt collector can't get it through a garnishment. They don't have a home, so the lien can't be placed on their home. They don't have any other personal property, so that could be seized. So they're really safe from collection. If someone is vulnerable to collection, then you work through, if they still have no ability to pay, maybe it's still a cease contact letter saying, I can't afford this debt. If and when I can, I will contact you, just to preserve someone's sanity. Sometimes it's a payoff. Often a referral to a credit counselor is really helpful. So I think all over the state, there's consumer credit counseling services. I could easily be wrong about that, but if you have the ability to refer to a free credit counselor, either for a phone or email or internet or in-person appointment, that can be really good for people. And then of course, as another option is a Chapter 7 bankruptcy. And included in the materials is MidPenn's bankruptcy screening tool that can help you make that assessment. I think the other big takeaways are just always limit communication to preserve people's sanity. Have them choose how they want to be communicated with, if at all, and send a letter saying so. And I always ask people to be on the alert for debt relief scams. There's so many companies out there that are truly scammers who are charging people to, to resolve their debts. We'll take care of everything for you, send us money. And so often those end in disaster and no relief for the consumer. When people call and just say, I don't even know what this debt is, who is this company, or maybe I know this debt, but it's for 3 times as much as it should be, that's when you can use the FDCPA's dispute and verification process. So the FDCPA gives everyone the right to, within 30 days of the first written notice they receive about a debt, to request verification of it. It sets out in the statute what that verification has to be, but it has to at least include the name of the original creditor, and the amount. So, and even after that 30 days has passed, the consumer can always dispute a debt. It's just the reason that we have them merged into one letter in the sample materials is because it's convenient to do it at once. Say, I'm disputing this debt, I'm requesting a verification letter. And what's key here is that the debt collector has to hold off on any more communication about the debt, any more collection about the debt until they provide that verification. It can be really useful in this situation to request credit reports as well for the client, so that they can, if this is a weird mystery debt showing up, they can go look on their credit report, figure out if it's identity theft or if it's maybe is an old debt that was sold to another collector, try to figure out what's happening here. In the materials, we have really step-by-step instructions for requesting credit reports online. It can be a little bit tricky, so Ryan was nice enough to provide some really great materials that you can hand to someone they can take home with them and follow the instructions. Also good for advocates to follow. If it looks like it is ID theft, this is just some ideas about how to protect someone as much as possible, to document the ID theft and to try to prevent any further ID theft. So a police report's always a good idea. Call the non-emergency line. And people often feel really silly saying, I'm not calling the police about an ID theft that happened 9 months ago and I just discovered, but down the line, someone's going to ask for it. So call the non-emergency number, say you want to make an ID theft report. The FTC, the Federal Trade Commission, has a pretty good website that includes a way to do like an ID theft affidavit. So, and the point of, I always tell people, the point of doing that, it's not like that's going to solve all your problems. It's not going to undo the ID theft. What it gives you is documentation that the ID theft occurred, so that if in 2 years from now you get sued, you can say, look, this is ID theft. I was saying it was ID theft 2 years ago. And it also gives the consumer a recovery plan. It goes through credit freezes with the credit reporting agencies. It provides sample letters to send. It's a really decent step-by-step recovery plan that they tailor based on the identity theft you've identified. I think, yeah, so I mentioned that it helps. It also includes information about disputing the debts with credit reporting agencies to try to minimize the damage to your credit. Another important protection for victims of identity theft is the right to request records related to the identity theft free of charge. So the Fair Credit Reporting Act includes this protection, and it says that businesses have to provide free records with whatever records they have within their possession to a victim of identity theft within 30 days, and they can't charge for it. We have a sample letter in the materials that, and when I say sample, you'll see it's fill in the blank. So it's a letter you can hand out to a client or one that you could edit to send on behalf of a client. Businesses have the right to require proof. They don't always, but sometimes they do. So that's when it's great to have a police report. It's great to have an FTC identity theft affidavit, or anything else that the business might ask for ID, a couple other things. And so it's always good to have those just to be safe. Sometimes people will call and say, I just got my credit card bill and there's a charge on it I don't recognize, or I always pay my bill, I only ever put a couple things on it, I pay it every month, and this month it's really different. So there's two laws that are important, that provide important protections for people dealing with credit or debit transactions they don't recognize. So for credit billing errors, the law is called the Fair Credit Billing Act. And it requires credit card issuers to investigate and resolve billing errors. It's important to report as soon as possible, because the sooner you report it, the better. And there is a hard 60-day limit from, I think it's 60 days after the error appears on the statement. There's a timeline in which the credit card issuer has to acknowledge it, and they need to send written explanation. And while that investigation is pending, the consumer can withhold payment of the disputed amount, which can be huge for people. If you don't get and we have a sample letter here that you can give out to clients. If you don't get a satisfactory response, advise your client that they can make a complaint to the Federal Trade Commission, to the CFPB, that's the Consumer Financial Protection Bureau. And there's also a private right of action under the statute. So there's a 1-year statute of limitations, and you can get actual damages and finance charges and attorney's fees. So I don't know how many people in the state are bringing these cases. I personally am not, but I always advise people of that if they're not happy with the response. Sorry, sometimes my clicking stops working. Okay. So very similar protections for debit transactions. It's actually broader than debit transactions. It's unauthorized electronic fund transfers. So for short, the shorthand is to say debit card purchases, but it actually covers ATMs, direct deposits, and for people who have their debit card linked to an electronic payment app like Venmo or Cash App or PayPal, it would, those are implicated too, because the actual charge might have occurred over the platform, but the account from which the money is drawn would be the relevant entity to send the dispute to. So I have my checking account with PNC linked to my Venmo, so I would send the dispute to PNC. Again, we have a letter here, a sample in the materials. This is for unauthorized transfers, which is pretty narrowly construed. So it's a transfer from the consumer's account by someone else without the account holder's permission, and from which the consumer receives no benefit. So you can imagine a lot of scenarios that don't fit that perfectly. Here, and this is where it's really important to report, not just within 60 days, but as soon as possible, especially if it's related to a lost or stolen card. Really, 2 days is the magic number for the highest level of protection against fraudulent purchases. But again, it requires the bank to investigate and provide a written explanation. And there's also a private action under the Electronic Fund Transfer Act.
And Laura, there was a question in the chat about that for both of these, disputing credit and debit transactions. Who would you be suing? It would presumably be the credit card company and the bank that you have the card with. Is that right?
Exactly. Yes, thank you. And one note about this is it's important, the address to send the letter to is sometimes not obvious. If people just look on their bill and send it to the payment address, it's probably not going to even get responded to. It's important to turn over the bill and look at there's usually on the back of the bill, it will say for billing errors, or I think it's for billing inquiries, usually send to this address. That's where the dispute letters need to be sent for both credit and debit disputes.
One more question in the chat, and may or may not have an answer to this one. What is the responsibility of the bank to contact another bank to stop a transfer of funds due to theft? This might be beyond our scope.
That is beyond my scope personally. How about you, Ryan? I would have to look in the statute for that. I did include at the last slide of this PowerPoint. There's a list of resources that includes some really good information from the FTC and the CFPB on all of these. So if you don't want to go hunting in the statute, you could probably find that answer there. But I don't know that off the top of my head. All right. Okay, this is, did I just skip one? No, okay. Just looking at time. All right. Frozen bank accounts. This is probably half of the new clients that I get are coming in the doors because their bank account is frozen or they've received a notice that their account, that someone's trying to freeze their bank account. So the first question is to figure out whether the funds should be attached at all. And when I say attached, I just mean frozen by the bank, because a plaintiff, a judgment holder, is trying to seize them. This is every time I deal with these, almost every time I end up looking up the rule. So I put the rules on the slide, but really generally, the first 10,000 in each account where any exempt funds are deposited, I'll use Social Security as the most common example, is initially protected from attachment, meaning the bank should not freeze it. And then if sometimes this doesn't come up much for our clients, but if you have more than 10,000 in your bank account, then, and it's all exempt, that's also protected. For someone who has no exempt funds, our rules only protect the first $300. So if you are a worker and all of your funds are wages, you only the first 300 is protected. And banks will typically seize that, and the person has to call or go in and say, I need my $300. Some banks make this way harder than it needs to be. They say, send a letter to our out-of-state garnishment counsel to get your $300. That is unacceptable, and usually if you call the bank to get through to their garnishment department, you can get someone to release the money. There's a long list of exempt income and other resources, Social Security, pension, retirement funds. It's a very long list. You can look up the rule to see the full list. But that's the first thing, is to figure out whether the bank should be attached at all, whether the funds should be frozen at all. If not, there's a few strategies you can take. You can call the bank right away and say, hey, this is a mistake. You can if you happen to be familiar with plaintiff's counsel, or if you just want to take a shot, you can sometimes call them and say, look, this is a mistake. Here's my client's Social Security award letter. Will you please dissolve the attachment? And sometimes they will. And then as a last, if neither of those work, and then you can file a claim for exemption. Oh, sorry, I should just note on this slide, really important advice for your client is to not move their money around. If they get exempt funds, keep them in the account where they're deposited, because that's where they're the easiest to protect.
One more thing, Laura, is an instance where you might have over 10,000 is if you had back pay from Social Security, waiting for a long award for SSI or SSDI, you might have a large lump sum. And I think I did provide you with a handout. I don't know if we were able to get it in the materials in time about collecting garnishing wages and stuff like that. It's got a lot of references. It's in like paragraph form, and it has citations to the relevant statutes for most things you might deal with on collecting judgments.
Thank you for mentioning that. Yes, it did make it into the materials. I learned a lot from reading it. And I'll just say, I put this on the slide as a hopeful challenge to everyone. There's a rule that says that execution, including on people's bank accounts, may be stayed on any legal or equitable ground. To me, that means any equitable ground. For instance, by saying there's a pandemic and my client has no money. I've never tried this. If anybody tries this to get someone's money unfrozen, please tell me about it. I haven't had the opportunity to do it yet. But here's the process. I'm looking at the time and realizing we only have a couple minutes left, so I'm going to cut this short. But if exempt funds are attached, and they shouldn't be, and you aren't able to get them released any other way, you can file a claim for exemption, and then a hearing should be scheduled within 5 days. In Philadelphia, it's never scheduled within 5 days. I don't know about other counties. But if you include a demand for a prompt hearing, it should be within 5 days. Okay, so I'm gonna skip over, I'm just gonna note what's on these slides and then skip over them for the time being. And if we have time, I'll come back to them. High cost loans and illegal payday loans. We have a really fabulous sample letter in the materials from my colleague, Carrie Smith, that people can, if someone ends up with an illegal loan because the interest rate's too high and Thankfully, payday loans are illegal in Pennsylvania. This, you can give that letter to a client to send, telling the people to never contact them again and never touch their bank account again. Student loans, I mostly put a collection of resources together, helping people figure out what loans they have and what, if anything, they can do about them, and warning them away from student loan debt relief companies. I think this is a huge one. The federal student loan servicers are not great, but they are required by law, by their contracts, to provide services for free to federal borrowers, and there's no reason to pay a debt relief company to do it. Business disputes and scams. This is just essentially a collection of where to make complaints and how to figure out where the entity is licensed. If anyone was ripped off by a business or by a scam, there is a huge surge in scams right now. The FTC has a pretty decent consumer-friendly website that goes through all the scams, and they're also collecting complaints. So I think that those entities are probably flooded right now with complaints, but the AG's office continues to say to send them any COVID-related complaint especially.
Laura, I'm sorry, this is Kelly. I'm just going to interrupt for a second. Attorneys on the call, if you're requesting CLE credits, please respond to the poll that's on your screen right now. It'll be up for you for about 1.5 minutes. And Laura, please feel free to continue.
Thanks, Kelly. I'm actually going to pass it off to Ryan now.
There's your timer.
Yeah, to talk about collection action. So the most common, I'm being sued.
Yes, I'm being sued, defending collection actions. We, as Laura said earlier, collection actions, as we kind of define them all, oftentimes is between a creditor and a collector. So there are many different ways to handle those cases, but we're going to talk a little bit about debt collectors here. It's a huge industry. We have $13.7 billion industry affecting 70 million consumers. You think about how many credit cards everyone has, just think about yourself and your family, and now put yourself in a worse financial position. And credit cards oftentimes for our clients are a way to make ends meet between paychecks. They're often a way to afford food and necessities. Yes, there are going to be people that abuse them, but most oftentimes what I see are individuals who were making do. They were stacking cards, and you pull one of those cards out, which is a lost job, which is medical debt, which is something happening to a family member or a car part that needs replaced. And a lot of people will cite to these numbers. This is from last year, I think, about 50% or somewhere around there, people having less than $500 in their bank account. So these credit cards are what people use to get by. And what you find out is once you pull one of those cards out from that, or one of the Jenga blocks out, the whole tower comes tumbling down, and you find clients who have 3, 4, 5 credit cards, maybe all $3,000, maybe some with $10,000, and then it gets so far away from them. So what happens with these debts is some people or some credit card companies will try to collect them themselves, places like Discovery, Citibank, Bank of America. There's some that will go to try to do collection actions, but a lot of them will sell them off. They'll sell them off for 8 cents, 20 cents on the dollar. They'll sell 1,000 of these at one time, a portfolio of these debts to these debt collectors. And the debt collector, their job is to try to get as much money as they can and spend as little as possible. And so their strategies are going to differ based on your state. And Pennsylvania has some really, really good things about how we have it. Like later on, we mentioned no garnishment, wage garnishment, typically for credit card debts. But there are some ways that our system is set up for the credit card companies. And so we can get to the next slide here.
Sorry.
That's okay.
For some reason, okay, go ahead.
All right. What these debt collectors often do is use the court as a default judgment generator or a factory. So in MDJ or MDC, Magisterial District Court, This is basically a default judgment factory. The way that it works is you file a complaint with the debt collector files a complaint, it gets served on your client, and then if your client doesn't file a notice to defend, and then the hearing shows up and they don't show up, the plaintiff doesn't even have to come to the hearing. They get a default judgment, an automatic victory. In Court of Common Pleas, obviously a complaint is filed, and if your client doesn't file an answer within the right amount of time or a responsive pleading in the right amount of time, the case will go to default judgment. And this is just some quick numbers I pulled from 2019, Center County, 4 debt collectors first ones that came to my mind. It was Calvary SPV, Unifund, Portfolio, Midland, all of our favorite people. I found 137 cases just in 2019, and just in Center County has like 1% of the state's population. And that was just Court of Common Pleas. That didn't even count magisterial district court. And that's the type. Most of those cases are not being defended. Most of those cases, those people are not being represented by anybody. So there definitely is a place for advocacy in these areas. And the harms, obviously, systemic abuse of the justice system has a disproportionate impact on communities of color. And we are using our good money to pay these debt buyers who all their sole purpose is to feast on people like our clients. And the issue here sometimes is we don't know who they are. And so there are times where you could be dealing with somebody and maybe they've sold it. I have a case in the Court of Common Pleas, and I've been challenging the assignment, and they have like 7 assignments, and it's from this person to this person, this person to this. I mean, the chain of title, you can imagine the areas where you could challenge these type of cases. And there's a good ProPublica article that just came out. Laura and I had each saw it. And it's talking about one of the biggest debt buyers in the nation saying on its earnings calls, like, we're doing great. And part of that is taking people's stimulus checks, and it could be usually, I'm assuming it's for judgments that they already had against individuals as the courts were closed. But they don't sleep, so.
Okay.
So some initial considerations when you're getting a case is when you talk to a client, they're not going to remember generally all of the credit cards they had, especially because by the time they get to you and they're getting these letters from these debt collectors, a lot of times it's been 2-3+ years since they had this credit card and since it was charged off. And so a good thing to do, and this is usually what I do, or if it hasn't already been done by the time the case gets to me, is to run a credit report. We included, as Laura said earlier, some information on how to pull one of these. It's fairly easy, other than there's a multiple choice questions on there that can throw people off. And so what you need to do is assess the situation, because you could get into a situation. I have a client I started to represent, and they'd been sued in the Court of Common Pleas, and I decided to file POs. I got invested in this case. And while representing, and I'd already gotten POs granted, another case came in from a different debt collector. And so I thought, well, I've already spent time on this. I'm about to get this other case dismissed. Might as well defend this action. And what do you know? 3 cases in 2018 filed against my client, 3 separate debt collectors. And so you got to know what's on the horizon with your clients, learn their goals, to try to figure out exactly what you're going to do and why you're doing it. Because as I said, there are hundreds, thousands of these cases that go. And if you get to the point where you want to start doing these cases, you're really going to have to assess, what your resources are, what you're going to be able to do in terms of devoting your resources. And you're going to have clients who are going to want to pay. They feel bad about this, and maybe that's a good thing. If they didn't, maybe they would be something wrong. But you also have to help them understand that this is just the system. That we don't know who these people are, and that's kind of how I often talk to my clients about these cases. Is we have no idea who they are. Yeah, we want to pay our debt, but we want to make sure we pay the right person. So let's make them prove who they are before we give them all of our money. And so that usually helps them understand the case. And at the end of the day, it's you say you are, prove it. That's where you coming in and knowing who your adversary is. Are they original creditors? Are they debt buyers? They're all going to have different strategies on how to handle them because these debt collectors are volume businesses. If you ever have seen a complaint before, they are auto-generated. They have some hot doc type of system, and they pull information. And a lot of times they'll say and or is, and they'll have like a list of 3 things of what they may be and what kind of debts you may or may not have. And so the fact that they do this on volume means if you come in and muck up the system, you might have some leverage over them. And so there are going to be other considerations. Is it at the Court of Common Pleas or in a small claims court? There are different strategies on how to handle those cases. We'll go into those a little bit later. And ultimately, if you have a client who has a lot to lose and has a lot of debt against them, one of the things you're going to want to really do is assess whether a bankruptcy is appropriate. Are you going to just defend a case and there's 10 more people in line behind them? And so you're really doing nothing, or is bankruptcy really a good option for this client? So that's something that you're doing at the very beginning is in assessing the case. There are some. So this is the plaintiff's burden. These are the type of cases they often bring. The most common are normal contract cases, and then the ones I see along with those are account stated theories. That's usually like they don't have a contract because they don't have any documents. It's kind of a good tell that they didn't get everything when they bought the debt. Because what they do, I should have gone into this a little bit, is they buy these debts, they get a huge file of documents that have been scanned, and sometimes they don't get everything. They might get a contract, they might get a couple of statements of accounts from the client, or for the client's file, or they might have way more. Sometimes I think it's related to how much you want to pay for it, and so that's going to be a good tell, is the type of theory they bring. If they don't bring a contract theory, that means that they got a weaker case. And just like every other contract, you need offer, acceptance, breach, damages. And for debt collectors, they have to show that they have standing. And so that's just an extra level that they have to come in there and prove, show that they are who they say they are. So we'll just skip to the next one. Yeah. I think that's your slide.
Okay. Great. So common defenses, not my debt. I already paid this debt. I don't owe them anymore. I owe some, but not this much. And sorry, I'm trying to get my screen sorted out here. I don't have to repay the money because the debt is too old. Or this is probably the one that's true in almost every single debt buyer case. I've yet to see a debt buyer case where this is not an appropriate defense, which is that the company that's suing me is not the company I owe money to, which is what Ryan was just talking about. So I'm not going to go through each of these for the sake of time, but these are some of the most common defenses that might be available to your client. And Ryan mentioned a little bit a couple minutes ago about how the debt could have been sold a bunch of times, which would make the case really weak. The reason it makes a case weak is because in Pennsylvania, lawsuits have to be filed by the real party in interest. So when a debt buyer, like I'll use Midland as an example, in Philly, they're the largest, they file the most cases at least. If Midland is suing your client, they are not the party to the contract. Midland doesn't lend money to anybody. So they have to prove why they're in court, why they're even involved, why they have the right to enforce the contract. There's really good case law on that. Because otherwise, when a suit is brought against the defendant by a stranger to the contract, meaning a third party who wasn't involved in the original contract, the person being sued has the right to see why the plaintiff has a claim against him. The risks here are real. It's not just like a technical defense. It's not like a nitpicky, highly technical thing as some judges think it is. The risk here is that a defendant will be sued over the same debt by different debt buyers. And this is not a hypothetical. This happens all over the country, and there's plenty of cases that you can find that show that. If anyone's interested in those cases, there's a link at the end of the presentation to I'll mention at the end, there's some materials that include some good string sites showing those cases. So this is huge for debt buyer cases, showing that you have the right to enforce the contract. And the way that, just before I move, the way that you show that is, in addition to showing the contract between the client, the person being sued, and the original creditor, so the credit card company and the customer, the debt buyer has to also show a contract between the creditor and themselves, creditor and debt buyer. If a debt has been sold multiple times, then they need to show every link in the chain. They need to show the credit card company sold it to debt buyer A sold it to debt buyer B sold it to the plaintiff. And that has to be in writing. If they, and if they don't have the original documents, they have to explain why they have them. They almost never have the original documents. They may have a little piece of a document, 1 page of a document. What's really common is they'll copy and paste 1 row of an Excel spreadsheet into a Word document and say, we bought this account, and they'll have someone who works for the debt buyer verify that they've reviewed computerized records, and I can say that we own this. There's a ton of evidentiary problems with that. It is not a contract, it is not a business record, and the debt buyer employees don't know anything about the creditor's records in general. So Ryan will talk more about business records later, but that is typically the defense and why it's usually a strong defense. Another common defense is statute of limitations. In Pennsylvania, most contracts have a statute of limitations of 4 years. If a contract is made under seal, that is all the way up to 20 years. But in the case law says that it's really the intent of the person signing the document, whether a seal will actually extend the statute of limitations out to 20 years. I have never talked with a client who has intended to sign a contract under seal. I had never heard of a sealed contract before I started at Community Legal Services a couple of years ago. So I think there's always a strong argument, even if the little tiny word seal appears underneath someone's signature, that there is not a 20-year statute of limitations. Sometimes even shorter statute of limitations could apply. For instance, a lot of credit cards are incorporated in Delaware, and some of their contracts reference Delaware law, which has a 3-year statute of limitations. So it's always good to check for that. When you're trying to figure out whether it could be time barred, it can be a little tricky to figure out the date of default. Don't just go by what's alleged in the complaint or in the the boilerplate few sentences that you get. The plaintiffs often will not include a default date, but if they do, it's often not reliable. One way to do it is if you have a charge-off statement, you can typically subtract 6 months from the date of the charge-off statement. And that's because normally industry norms are for credit card companies to charge off a debt 6 months after default. You can also check the credit report, but be sure you're looking for the first date of delinquency rather than the charge-off date on the credit report. And one big warning here is be very careful when you're talking with a client, no matter where they are in the process, whether they're being sued or not, about reviving statutes of limitations. It's very common for debt collectors, the scummier ones, to call and say, hey, you owe us $5,000, but for a limited time, if you make a $20, we know times are tough, if you send us a $20 payment, we'll work with you, and you can let us know when you want to send the next one. That is a red flag that they are just trying to bait someone into making a payment in order to revive the statute of limitations, and meaning start the clock over again. And you can certainly make arguments that kind of a payment does not start the clock, but that's what the debt buyers are going for, and that's what you have to be careful of. I'm sorry, the debt collectors. Another thing is when you're looking for defenses, also keep an eye out for affirmative claims. So violations of the consumer protection laws, federal and state. It might be, calling at the wrong times, calling too often, contacting the wrong parties, demanding the wrong amount. That's a really common one. Another really common one is making threats of litigation or arbitration when the complaint is time barred. When the debt is time barred. Or any threat. Another common one that I've seen a lot recently is when someone requests verification of the debt collector will respond and say, we will send you verification as soon as you make a payment. That is not the way that the law works. So that would be another violation to keep an eye out for. And just
There's a question, one question here, Laura, real quick. Does the payment revive the statute of limitations, or verbal communication of the debt revive the statute of limitations? I think it depends, right?
It has to be a clear acknowledgement of the debt and an intent to pay. So I think if what they'll usually try to do is have a recorded line, and they'll try to get you to say on the phone, oh yeah, that's my debt, I remember it. I'll pay you $20 next month. I don't actually think that the payment has to have gone through, but you know what, I don't know the answer to that question, so I won't guess. But I know it's that you need a clear acknowledgement and an intent to pay. So if someone is just stressed out under arrest and they say, I'll pay you $10 if you just stop calling me, you have a strong argument that that is not a revival of the statute of limitations. And why would they demand the wrong amount? I think when I don't know about you, Ryan, most commonly when I see that, it is that they are demanding too much. They're demanding, you know, either a disputed amount or an amount when, you know, the client is sure that they've made payments on a balance down to a certain amount and those payments weren't credited. Or I've seen calculation errors from attorneys' offices where they just are demanding the wrong amount, and they are very quick to apologize and correct it because they know that they're at risk when they do that.
Yeah.
And then this is just the case law showing that debt buyers are debt collectors. They like to think they're not, but it's very clear in the Third Circuit that debt buyers are debt collectors. It doesn't matter if they outsource 100% of their collection to a third party. LVNV is the one that I think of for this one. They don't do any of collection on their own. They outsource almost all of it, as far as I know, to a company called Resurgent. But that doesn't matter. It's if their principal purpose is the collection of debts through any means, they are debt collectors. Okay, Brian, back to you.
Yeah, just briefly, if you ever do go to court on these, a big thing is to insist on the plaintiff proving their records. And so this can be done, you know, if you at an NDJ hearing or municipal court hearing by objecting whenever they try to introduce anything. We have quite a large list here, but so in addition to this, and I think concurrent with this, you'd go to the rules of evidence and look at it. What is it required to get a record of a regularly conducted activity? What, you know, we don't just let them, oh, you got a record, it's good enough for me. I object. This will get into strategy a little bit later, but what to do in different courts. But don't let them off easy on these things. Make them prove their case. One of the things that I do a lot of times, you touched on the assignment earlier, Laura, is their assignment will reference like 10 other documents that they didn't include with their assignment. So the assignment will say, this is an assignment in accordance with the agreement, or something like something known as the agreement. Well, they didn't attach the agreement. And so, you know, just requiring them to provide everything that they should have, and you're just making them prove their case. I mean, you're almost like a criminal defense attorney, and you don't have to make a case. All you have to do is say you didn't meet your burden. And so that's typically how I will handle these type of cases.
Great, and I'll just note that this doctrine of incorporation thing,
Yeah.
Debt buyers don't get to say that their business records are trustworthy just because they rely on them. When they're relying on business records from a creditor, they're not their business records, and the mere fact, the Superior Court has held that the mere fact that the debt buyer relies on them does not mean that they're a trustworthy business record. Okay, go ahead, Ryan, sorry.
Yeah, and then there's a question here, can counsel submit statements at arbitration without a party present? The rules of arbitration do allow for certain types of documents to be provided, as long as you provide them ahead of time, it's 30 days before the arbitration. So you want to look at the rule to see what's allowed. You can still challenge some of that stuff, but it can be a little more difficult if you wait till arbitration. But Laura knows more. I try to not let anything get to arbitration. That's my strategy. So.
Sorry, I somehow lost my chat box for a moment. I don't, yeah, so I agree with Ryan. I don't, you know, unless the counsel, you know, Midland's in-house counsel often brings their cases. Unless he's an expert witness, I don't know why he would be allowed to present a statement of his client, of Midland. There are arbitration, you know, there are slightly relaxed arbitration evidence rules, but they still require the trustworthiness of a business record. And I don't believe that there's any, I don't know of any exception for this kind of, just having the debt collector's lawyer testify for their, essentially, which is what it sounds like that question is getting to. And there's another question here, Ryan. Can you recommend a good training on student loan debt, including servicers, structures and issues, private versus government loans, parent guarantees, statute of limitations, scams, forgiveness? I always start at NCLC's Student Borrower Assistance website, which I have a link to at the end of this PowerPoint and also in the supplemental materials. That is intended for borrowers and advocates, but it's really accessible and user-friendly. And then from there, if you have access to NCLC Student Loans Manual, that is the next, if you have that access, that's the next best thing for sure. And yes, these slides will be available for download, and so will the supplemental materials. We packed a lot onto these, knowing that we wouldn't have time to touch on everything, but hoping that you can go back and reference them later. All right, Ryan.
So getting into the next one, just really quickly, strategy in different courts is, how do you handle these? One of the things I'll do is establish, is it a collector? Is it a creditor? What court are you at? MDJA for me, or MDC, or municipal court versus court of common pleas. And so the strategy will be different. For MDJ cases, I find them to be the easiest. And so what I do, technically, I would only need to do this for an original creditor. What I do is tell my client, don't show up. I'll enter my appearance the day of the hearing. I'll tell them to do the notice to defend, which is you got to do that ahead of time. I'll show up the day of the hearing. My client will not be there. And plaintiff often doesn't even show up, or they'll hire a local counsel. And then there will be no one to testify to any documents. And so they will have no case because their attorney or the local counsel that they hire, this gets back to business records or just gets back to someone's personal knowledge. I mean, there's a lot of evidentiary flaws with strategy for them to bring no witnesses. The reason you definitely, my strategy on this is definitely to do this for original creditors is that they will call your client as a witness and say, don't show a debt to us. You have a credit card with us. Isn't it, true that you spent $2,800? Yeah. And that you'll admit to everything. They don't need any witnesses. And so it is a strategy to not have your client go in those cases, but you will potentially get pushback sometimes from the other counsel who will yell at you for your client not being there while their client is not there, or you might get an MDJ who might tell you some choice words about your client, and you will just tell them that you'll expect the default judgment, in the waiting room or something like that. The other thing to know is that the evidence rules are slightly relaxed at both the magisterial district court and at the municipal court. There's a separate rule we referenced there. It does allow for bill, estimate, receipt, statement of account to be brought without a witness, but you still have to show it's made in the regular course of business. And this doesn't get a contract in, and this doesn't get an assignment in. So it might be something where they could show a statement of account, but they wouldn't be able to get anything else in. And so you should still be objecting as much as you can. In the court of common pleas, Laura and I have different strategies, but they're both really good strategies, I think, is I try to file preliminary objections and try to get the case dismissed without ever going anywhere. And so sometimes that does require filing multiple sets of preliminary objections. And depending on your county court, they might have requirements on oral argument, which may or may not be a good, detriment to you wanting to do this. They may or may not require briefs. I have courts that I go to that some require one, some require the other, some require both. So that would be part of your strategy. When you do this as well, you're going to piss off whoever the debt collector attorney is. He's probably going to start remembering who you are, and may start sending you discovery requests. And so you might have more on your hands than you had initially anticipated. One of the reasons to not do that is to just file an answer is because these complaints are terrible. And so it's pretty easy to file a good answer that get around anything that they say, and then just to fight it at arbitration. And then they usually will not build up their case enough, and they'll show up unprepared at arbitration, and you'll go before 3 other attorneys, And then, they'll have to explain how this case meets the muster. And you'll be surprised at how many judges and how many attorneys dislike these types of cases and maybe wish people would fight them more often. I know I've heard from local counsel who will go to arbitrations and say, if you're a debt collector, you're just not going to win. They're gonna lose there. So how often do you see de novo appeals by creditors from losing an MDJ? So that's another thing that can happen. Obviously, if we win and get judgment at the MDJ or municipal court, then the debt collector can file a notice of appeal. They have 30 days to do so in MDC. So sometimes we see that. I find that it really depends on how big the debt is. And so we have a lot of clients who will have $2,000 to $3,000 debts. And those ones I don't see appealed as often by debt collectors. If they're an original creditor, they might. And especially if it's a bigger debt, it may be more likely. So that's another strategy. Sometimes we skip that step knowing that they likely would appeal. Let's not waste our time. And we'll just appeal and then require them to file a complaint.
Great.
Ryan,
Yeah.
sorry. This is Kelly. I just need to launch the second CLE box poll. Attorneys, you'll have 1.5 minutes to respond. Thanks, and please
Kelly,
continue.
I see that we are up on time, so I will speed through these last, I think we have 2 slides left.
Yes.
Okay, so post-judgment cases. If you are someone who takes these cases or you're interested in taking them, you should be aware that many of the cases that come to us, at least at Community Legal Services, come post-judgment. The person finds out about it because their account's frozen or through some other means. Their bank account's frozen, I'm sorry, through a garnishment. That person is not necessarily out of luck. You can determine whether there's a basis to petition to open the default judgment. It's a 3-factor test. They need to have a good reason for failing to appear originally, so either failing to appear at their small claims hearing or failing to file an answer in common pleas. They need to show that they've acted promptly to petition to open the judgment once they find out that the judgment exists. So I have a lot of clients who don't find out about their judgment till several years later, but once they do, that's when the clock starts ticking. And they need to be able to state meritorious defenses. So, I believe that the plaintiff doesn't have standing. You are not required to prove them in the petition. And this is an equitable analysis. The court is supposed to be focusing on whether this was a deliberate decision not to defend by the defendant or whether it was an understandable, reasonable oversight or impossibility. If it wasn't proper service, they couldn't possibly have appeared at their hearing. Petitions to open are great for opening judgments. They're also a really good negotiating tool. Sometimes just calling an opposing counsel and saying, hey, we're talking with Miss Johnson over here and trying to determine whether she should file a petition to open. Sometimes that's enough to get them to agree to vacate the judgment or to settle a $5,000 debt for $100, some token settlement, just because they don't want to litigate a petition to open. So just be aware of that. And
Laura, you said you do those in municipal court, correct?
I do, yeah.
Not just the Court of Common Pleas. That's Court of Common Pleas is my understanding. I don't know the MDC rules. I couldn't find anything about that. I know that you can do writs and challenge certain things, but only in certain circumstances. So that might be an option available at MDC, but it's not my practice or knowledge that it is. So it might just be one of those distinctives.
Yeah, I learned a lot about the differences between municipal court and MDC from the MidPenn memo that's in the materials. I'm sorry, I don't have any information on that. So consider settlement only if your client wants to pay the debt and the plaintiff proves it owns the debt. We listed some important considerations here. I won't go over them because I want to be respectful of everyone's time. But if you're going to settle, try to follow these rules. I'm sure that there's lots of other things that make for a good settlement, but I think these are like the bare bones basics. I've referenced a lot. We've both referenced a lot of resources through the course of the hour. Here's a collection of everything I've referenced, all the places to make complaints, some sample letters from the CFPB and the FTC. And down at the bottom here in bold, this is a much longer training on collection actions that goes into depth and has a training manual that includes sample pleadings. So if you're someone that takes these cases already and you're looking for that more in-depth level, that's one place to start. And I think that's it. So I would just also point people to the supplemental materials. That's where you can find all the sample letters that for your clients or for you to use.
And quick pitch for a Zoom group that Laura is going to be starting here soon for other consumer advocates to talk about cases and strategies and ideas. So be on the lookout for that on the state listserv.
Yeah, I'll send around the listserv. Hopefully it'll be in October. And I think a lot of people who work on these cases might be the only people in their office that does them or in their county. So if I would love to, Ryan and I have found it really valuable to share information and strategy and material. So if you're interested in that and you haven't already been looped into that, please, you can send Ryan or me an email or respond when we share it on the listserv. And with that, thanks everybody.
Thanks, Laura and Ryan, for your time and all this great information today. And thanks everyone for joining us. Everybody have a great rest of the day and take care.
Thanks, Kelly.
Bye.